Sir Edward Coke is an amazing figure in English history who's had an extraordinary influence on American history, on the history of the common law, and in fact on the history of the idea of the rule of law as it is understood the world over. Coke rose from this rather obscure beginning to become the most powerful judge, perhaps the most powerful lawyer in the history of English law. Coke was both revered and despised in his day. It's very difficult, I think, to understand the nature of popularity in the Elizabethan world, and Coke was very much a creature of the Elizabethan world. Coke was very popular at court, unless he was absolutely hated at court. But there are a number of people who were like that, and unlike most of them, Coke ended up living out his entire life to a natural death. There was, I think, a trend in which Coke over time became more and more a person enamored of carrying out the truth of the matter and the justice of the law rather than the will of the king or the demands of the powerful. And as that went on, he grew more beloved by the literati and by the common people, and a bit more dangerous in the minds of the monarch. Very early, Coke's independence, Coke's commitment to the law and his commitment to the jurisdiction of the common law put him at odds with the powerful nobles and the church of his time. And so he asserted the need for a uniform legal system so that the English citizen, the English subject, would not be subject to competing jurisdictions, competing requirements, competing taxes, but would have a single common law throughout the country and one single standard of reasonable law according to the ancient constitution they'd be held to. Well, this is not the way to earn the love of a monarch or the nobles who wanted those powers for themselves. And they understood all too easily that if the law is going to be the single source of all these powers, that means the judges are going to gain power at their expense. And I think the tipping point came when two different events took place not long before he was removed. The first was that the great royal advisor, Sir Christopher Hatton, died. The second was that there were several trials in which the king had expected one result and Coke had found otherwise because the evidence demanded it. We saw this as an opportunity. The professional staff at Liberty Fund and I and my colleagues in legal history around the world as an opportunity to put something of Coke's greatest hits together. We had to squeeze into 3 volumes, the very most important of his writings from the institutes, the very most important writings from the reports, also the most important of his parliamentary speeches, and then a few of the excerpts from some of his lesser-known writings. The first volume of Coke's selected writings comes from the reports. The reports were his publications of cases, especially the arguments and the resolutions of the judges. The first volume was published in 1600. That was while he was Attorney General. The last volume was not published until long after his death. These 2 volumes had been in his private papers and had been seized by the king from his deathbed house. They were only published after the Civil War under a decree of Parliament restoring them to his sons. Volume 2 has selections from the institutes. The first volume was published during Coke's lifetime in 1628. That is his very, very famous book on property law, Coke on Littleton. That was the property book for over 150 years, not only that guided the development and the use of law in England and in its colonies and Commonwealth possessions, but also was the primary training tool used by lawyers for a century and a half. The methodology that Coke employed, the exegesis of Littleton's tenures, the earlier feudal property book that Coke's annotations had updated, these were seen by not only Thomas Jefferson, but many lawyers as the acme of common law reasoning. We do believe that a very early copy of the first institute was probably in the possessions of the Puritans in Massachusetts very early. Whether it was actually aboard the Mayflower or not is not something that I am confident of. On the other hand, it would have been very plausible. It would have been the most significant law book of the time. It would have then been very fresh. And certainly Coke was very well regarded by the Puritan lawyers. I think that it is safe to say, though, that some of the most enduring contributions that Coke made to the life of the law, he made standing in Parliament. And so I think it is important to understand that in many ways, the idea of the law as an independent artifice based upon an ancient tradition of the respect of individual liberties protected carefully by law, uniformly applied without regard to the power or to the wealth or to the poverty or to the religion of the person against whom the law might bring its powers. The parliamentary materials were often the hardest to find, and also some of the more specific royal documents and instruments that affected his parliamentary and judicial career, rather difficult to find. A few of the materials, especially in Volume 1 relating to his life, had not been printed before, although they were available. So it was in making those accessible to the modern reader, creating translations that would be successful, that would stand up to the most careful of scrutiny, and making sure that we were true to the Liberty Fund ideal of bringing primary sources to the reader with as little interference as possible. Coke was a voracious reader. He mainly read law, and so he certainly was familiar with many of the materials from antiquity that informed most of the educated readers and writers of his age. But he read some of the materials that Liberty Fund has recently published in the classics of the Enlightenment. He was familiar with Grotius, he was familiar with some of the other continental writers, but not as much, perhaps, as some of his civilian counterparts might have been. He collected widely, he read widely, he knew geography, he read a lot of histories. I think it's also important to understand that Coke had a view of England that was informed by more than just the books. He had a love for the antiquities of England that is not visible except in the reading of his writings. It's not so clear in the writing itself. It would be a choice, I think, if it was to be just an opinion of his. I think it would be the opinion in the case of Dr. Bonham, which is probably his most famous opinion. And it is one in which he is not only very carefully and methodically laying out a methodology for hearing a case, but reaching the amazing conclusion, very common to modern ears, but one that at the time was perhaps almost earth-shaking. And I say perhaps because it might also have perhaps been as common to them as it is to us. It's a matter of great debate. And so because of that debate, I'd say not only is it a fun read, but it's an important read. Well, I do use a great deal of Liberty Fund materials in different ways. They've certainly informed my research a great deal. Generally speaking, I use Coke's materials in surprising ways in my classes. And so I use the Liberty Fund materials, especially from the reports, not only in my legal history class, but also in environmental law class. Aldred's case out of the reports is the first modern environmental law case. And so I assign different readings. And I also have to say that I use the online library of Liberty a great deal. There have been a number of students that have been working on papers, and also colleagues working on papers, that are very well informed from the online library of Liberty because there are resources there that I've been able to point them to immediately and easily, and that's been able to further their research. But what Pollock and Maitland did was to look back to some of the feudal laws that Coke had taken from either intermediate sources, such as Bracton or the Mirror of Justices, and move forward. And while Pollock and Maitland are very respectful of some of the things that Coke did, they very rightly saw Coke as, at times, a revisionist. And so they're a more meticulous, more scientific, much more scholarly, and I don't think in some ways it's unfair to say as careful, but they are much more careful to look at the wider array of sources that were available to them in order to look carefully at this very early origin of the feudal law. Pollock and Maitland are very respectful of what Coke was doing, even in those areas in which their areas of research overlap. Pluckett did a marvelous job for his time. We now know more about Coke, and we now know more about an awful lot of individuals than was available when he wrote. Sir John Baker has access to considerable materials that Pluckett would have enjoyed having. But the fact of the matter is that Cook is well represented, and I think fairly so. But I think it's also important to see Plucknett not only as an exposition of the law, but as an important artifact, the way in which the history of the law has been perceived. He is one of the most important of the modern historiographical evidences of the modern common law. Liberty Fund has done an incredible service to scholars around the world by bringing out this authoritative selection of the writings of Sir Edward Cook. It has made it possible for graduate students, for students in China, for students in India, for students in Australia, and students in America to have access to the architect of the modern common law as American colonists understood it and as American lawyers today still use it. Although it is very rarely taught, one of the reasons why it has been so rare for Sir Edward Cook to be taught was a lack of access to these materials. There is no question in my mind that we would not understand why every man's home is his castle, or why there should be no troops quartered in someone's home, why there should be due process of law, why we should worry about judicial independence, why we would even worry about the rule of law. None of these concepts would have been as significant to the American colonists, the American constitutional framers, or today would have such vitality on the world stage, but for their framing by Sir Edward Cook. Certain of his other ideas that are just as important will only grow and only be becoming more and more influential because of access afforded by these books. For instance, his idea that the law evolves by always allowing new corn to be brought from old fields. This is essential to understanding how the law is going to be able to deal in a digital age with new advances in science, technology, and new challenges as the population continues to grow. The idea that we can have the rule of law, a foundation that is enduring and yet flexible, capable of being fair despite change and despite challenge, despite those who would say that a moment of challenge to a government is the reason to reframe the law. This is his enduring significance, and it is that power that Liberty Fund has put very accessibly into the hands of students worldwide.